on their 18th birthday. Is that correct?
Correct.
That's your understanding.
Yes.
So that means that they won't be getting their money until sometime into the future, whenever they turn 18.
Yes.
You understand that? Also, on another matter, you understood, we talked about a Medicaid lien in the amount of, about $1,600, 1,630. And I indicated to you that Mr. Melendez was going to pay that out of his attorney's fees.
Yes.
You understand that, right?
Yes, sir.
And the final question is, are you satisfied with the terms of the settlement agreement? Just so that the court is clear.
Yes, sir.
Thank you very much, Ms. Dominguez. I have no further questions.
Mr. Gaddis?
Mrs. Dominguez, I just have a couple of questions for you, ma'am, and I don't mean to upset you in any way, so I'm just going to ask these questions. Please bear with me. Ma'am, does Alexis agree with the settlement of this lawsuit against Dr. Quesada?
We don't have any choice. Yes, sir.
And with regard to the minor children having medical issues, you understand, ma'am, that if there's an incurrence, if they incur medical expenses in the future, that you cannot come back and try to get more money from Dr. Quesada and his insurance company. Do you understand that, ma'am?
Yes, I understand.
Okay. And then as far as the minor children, ma'am, you understand that you're giving up their right to a jury trial. You understand?
What is that?
May I explain it to her? She's asking, she doesn't understand.
Yes, ma'am. I'm sorry. Yes, Mr. Melendez, if you can explain it to her.
In other words, you're filing the suit on behalf of the children, and today you're giving the court permission, at least from your perspective, that the settlement is in the best interest of the children. But when you do that, also once the court approves it, that you can't go back and ask for more money. That's no matter what happens. There's no more money available from this lawsuit.
Yes, sir.
So let me just stop right there, Mr. Gaddis. I believe Mr. Gaddis's question was, Ms. Dominguez, if you understood that by agreeing to settle, that you are giving up your right to go to a jury trial. That I understood to be Mr. Gaddis's question. Do you understand that, Ms. Dominguez?
Cause number 2022.
Oh, yes, ma'am. I don't have any choice.
Hold on a second. I'm getting a lot of background noise. Hold on.
Versus Enrique Garcia, Ricardo Ruda.
Your Honor.
Okay.
3 hearings at the same time.
Okay, Ms. Dominguez, I think I heard your answer correctly. Did you say, this is the second time I'm hearing you say we don't have any choice?
Yes.
Okay, I'm not understanding. Well, go ahead, Mr. Gaddis, finish your question.
Yeah, Mrs. Dominguez, I just wanted to follow up. Mr. Melendez did a good job of asking and reiterating that there's no additional money in the future, but as they said,
Mr. Gaddis,
whether
now
you
we're,
understand that,
Mr. Gaddis, where you're now your connection is interrupted. If you would please start your question again.
Yes, ma'am. Am I coming through okay, Your Honor?
I can
it's like
hear you
audio on both
right
sides.
now. Yeah.
Okay.
Go ahead and restart your question.
Mrs. Dominguez, do you understand that you're giving up a right to a jury trial for minor children?
Yes.
Those are all questions I have, Your Honor. Thank you.
Okay, I just want to make sure I understand from you, Ms. Dominguez. You understand you, by agreeing and asking the court to approve this settlement, you are giving up a right to go to a jury trial. Do you understand that? Is that a yes?
Yes.
Okay. It's a lot of technical issues here. Let's see, where did we start? Mr. Melendez, did you have any other questions? Mr. Gatt, thank you, Mr. Gaddis.
No, Your Honor.
Ms. Dominguez, I can appreciate very much how difficult all of this has been, and I certainly am observing that here today. So I want to make sure I understand fully that I understand that it is your position that this settlement, as has been proposed to the court on behalf of the minor children, is in the best interest of all those minor children that you are in custody, care of. I want to make sure I understand from you that that is what you're telling me.
Yes,
Okay. You said a couple of times we don't have any choice.
well,
Okay.
it's too hard for us. You know, they did a lot of mistakes in her. We have been suffering a lot. I'm by myself with them. You know, all what we have been going through, therapies, medicine. My house is so sad. We cannot go through this. And because they didn't pay attention to her.
Miss-
She was working a lot too. We were low income. She studied a lot. I sacrificed a lot for her to go to be a nurse. And she was trying to be an RN. And then she was trying to be a doctor. She worked so hard to push her kids up. And just because that doctor make a lot of mistakes, she's gone. We have been suffering a lot. And you think 4,900 or something like that cost her life? Is that the price of the life of my daughter? So believe me, it's really hard, but I don't. It's okay. Everything is okay. Everything is okay. Don't worry. But every day, you know, I'm 64 years. Every day, I'm praying to God to be alive because that's the only thing they got me. And their children, they are in this disabled. They're disabled. And I pray to God to live more so they won't be alone. So it's very hard. But everything is okay. I know Mr. Melendez did a great job. I know he has been with us working. But everything is okay.
Ms. Dominguez, I don't mean to it's more difficult than it already has been for you. But I need to make sure that I am clear that you are asking and believe that this is in the best interest of your minor grandchildren, and that you are asking me to approve this settlement.
Yes, yes.
I did not, Mr. Melendez, do you have anything else for the court?
No, Your Honor, not at this time.
So I did review, obviously, the ad litem report, and am going to, Mr. Gaddis, I continue to mute you because there's a lot of background noise. What I did not see was anything with respect to the ad litem fees. And I don't recall, because I think this has been pending for a while, if I received any proposed orders with respect to the court's order and judgment on this case. So, Mr. Dominguez, I didn't see Mr. Velante on the ad litem fees.
Oh my God, Your Honor, can I be heard?
Yes, sir.
I went ahead and prepared a second supplemental report of ad litem to tailor it to this settlement.
Mhm.
And I have not filed it because I was waiting for the results of this hearing. However, I will have it filed within the next couple of hours as soon as I get back to my office. Insofar as the attorney's fees, I was going to visit with Mr. Gaddis on that.
So in terms of the ad litem report, the March 27th one, there, you're telling me there's another supplemental?
Well, this one, the one that corresponds to Dr. Quesada. The other ones were structured settlements. This is not going to be a structured settlement, for one. And two, because this represented the last stage of the case, I had to visit with Ms. Dominguez, both Mr. Melendez and I, to make sure that she was fully satisfied.
So then I'm going to await the ad litem report, the
Yes,
final supplement on the ad litem report. Once I receive that, Ms. Dominguez, then I anticipate being able to finally approve to include ad litem fees. Once I receive that, we will set this for a status conference in 2 weeks. That will be my marker to make sure I have received all of the documentation pertaining to this friendly suit and settlement. Okay.
We will do that. And Your Honor, one other final point that is not related strictly to this hearing. However, it touches upon the settlement overall. In a previous settlement, we had agreed that we were going to set aside $10,000 for litigation costs. Well, that money was never used. So consequently, that money is going to be distributed evenly to both Ms. Dominguez and the 4 children, Alexis being the adult and the 3 minor children. And Mr. Melendez and I spoke about it this morning for the first time.
So, well, let me ask then, I mean, if there are additional monies, is that going to increase that per person settlement? Today was represented 4,680?
That's my understanding.
Okay, so that number is going to change?
Yes, ma'am.
Well, just so it's clear, that's a different settlement. So when we settled with Dr. Nguyen, that's where the March ad litem report is based on. We settled and that money, we waived attorney's fees, just took cost, and then we held back $10,000 in order to pursue the case against Dr. Quesada.
Okay.
And of course, the case is settled, so it was agreed that the money would be, the $10,000 would be distributed equally among the 5 beneficiaries. And so, but that has nothing to do with this particular.
Understood. Gotcha. I understand. Okay, so that is not affecting these amounts here. It has to do with Dr. Nguyen.
No, ma'am.
Okay.
No, ma'am.
All righty. Okay, then I do, like I said, want to review the ad litem report. Once I review that, then I receive Ms. Dominguez's testimony, anticipate approving the settlement. Ms. Dominguez, we will have a final hearing in 2 weeks just to square away all the documentation, but I want to commend you and extend, I guess, just my care and concern for you, and you're taking on so much of this responsibility. It's very clear to the court that this has been difficult, and I hope this helps you move forward, at least somewhat, to find some peace. Okay.
Thank you, ma'am.
All righty. We'll reset for 2 weeks for finalizing of the settlement. Thank you.
Judge, thank you very much. Adios. Bye-bye.
Thank you, Mr. Melendez. Thank you, Mr. Gaddis. I'm sorry, there was just so much background noise. I had to keep muting you. Okay, you all are excused. Who's next?
Thank you.
Page 4, Judge. Hello, page 4.
Mhm.
In cause number 2021, DCV 3473, Yaria Vasquez versus Gabriele Ruiz. Announcement of council, please.
Good morning, Your Honor. Gabriel Perez on behalf of plaintiff, Ms. Vasquez.
Good morning, Your Honor. Joe Garcia on behalf of Mr. Ruiz.
Okay, and we're set for summary judgment. Mr. Perez, you may proceed.
Thank you, Judge. Your Honor, we filed a partial motion for summary judgment ahead of the trial next week, simply as to the issue of liability. I think the evidence is clear in this matter that we've attached the excerpt of the deposition of the plaintiff as well as the law enforcement report that was produced in discovery by the previous counsel. What do you call it? Sorry, Judge, somebody else is messaging me on my screen. We haven't seen any evidence or any discovery produced that contradicts the liability of the defendant, Ms. Ruiz, in this matter. And so there was, I think, initially, Ms. Marquez had filed when she was handling the case earlier in the year, maybe last year, trying to designate a responsible third party for an unknown driver. However, as I filed a response to that portion, to that motion, that it was out of time, so she could not designate a responsible third party, which only leaves Ms. Ruiz as the liable party to the plaintiff as far as the causation of the accident, Judge.
All right. Mr. Garcia, I see you have a written response. Tell me what evidence you have.
Yes, Your Honor. Well, as far as evidence, Judge, I produced, the same information that the plaintiff is producing and showing the court that there's no evidence or no evidence of that we can produce. I think the evidence, even that they produced, is in contradiction of each other. For example, the police report does not mentions that the plaintiff was at a stop because of because of other traffic. And I'm sorry, the proper word would be she came to a stop due to traffic congestion. Plaintiff says I was at a red light. And even in her deposition, which we also attached, certain portions of it show that she says that she was at a red light and she was on the far right-hand lane. The police officer says they were in the middle lane. And I just believe that that is not sufficient evidence to show that my client is clearly at fault. In addition to that, we've attached in our response, not attached, but have mentioned certain case law, which mentions that whether being struck from behind raises a question is an issue of negligence or establishes as a matter of proximate cause is for the jury to decide. It's not for whether the plaintiff succeeds in proving negligence and proximate cause is a jury question. And the mere fact that there is a rear end collision does not present evidence of negligence as a matter of law. They must prove not only negligence on the part of the driver and show specific acts of what the negligence was, but must also prove proximate cause. I don't believe there's anything that shows if the negligence issue is met, I don't believe there's anything that shows that it was the proximate cause of the accident with regards to this case, Judge. And Your Honor, that's all I have.
Mr. Perez, do you have anything else?
Yes, Judge, just briefly, the report that's attached, that both of us were attached to our response and motion, the investigating officer does obviously cite Unit 1, which is Ms. Reese. She's the one that basically started, if you look at the narrative, started the chain of events that pushed the vehicles together, essentially the collision. It does state that Unit 1 failed to come to a stop, thereby striking Unit 2, then striking Unit 3. It doesn't state that there was any other contributing factors, and regardless of the lane, it could be in lane 1, 2, or 3. If you hit somebody from behind, it's going to obviously Ms. Reese is at fault for the collision. She started the chain of events. There was no other indication in the report or in the deposition that outside force caused the cars to come together, other than the fact that Ms. Reese just didn't stop in time.
And just to respond to that, Judge, I just believe that the contradiction in the plaintiff's testimony and the police report is a question of fact for the jury to decide.
Okay. So I'm going to re-review some of the one of the exhibits. Anyway, I'll have an answer for you by the end of the day, though. In terms of the trial setting, I want to give you all a heads up because I see that you all have provided so many of the pretrial documents, motion in limine, exhibit list, proposed charge. So far, we are due to start a murder trial Thursday. And by all accounts, if it goes forward, it is likely to last through next week. So I just want to give you all that heads up and see, I don't know, see if you all want to discuss a reset now or just wait. I just wanted you to have the heads up because I don't know in terms of travel arrangements, things of that nature. Mr. Garcia, I always kind of understand that you're not here. So we may need to look at that.
And I was going to ask about this, Judge, because as Mr. Perez and I also have another case set in the 41st on the same day. And I have another one on the 41st as well. So I'm not sure what the order of hierarchy is as far as who gets to go first or what. And I don't want to file a motion for continuance because I would like to try to get them all resolved if I could. But at least in the 41st, I know I have two cases with one of them with Mr. Perez as well.
Well, let's send this one over there. Maybe Judge Anna will take, and then you can have all your cases over there, Mr. Garcia. It's that, look, we're due to start jury selection tomorrow, assuming everything goes through. We have 2 days of jury selection. But definitely know by Friday. I think it's, unless I'm hearing some type of objection, I think it's likely that we are going to need to reset your case. I think that's a little more certainty than hanging on to see if at the end of the day, you all end up having a shot at next week. I don't like to put you all in that position. So can we agree to move this trial date to sometime this year?
Yeah, Judge, that's fine.
If you all are okay with that? Okay, so, well, let me see, hold on a second. No, yeah, that's gonna be a problem. That's gonna be the trick, finding a trial date. Okay, I may not be able to get you into this year. It may be March, going up through March of next year. Is that horrible? Is that?
I'm sure we both have a lot of cases set between now and then, Judge, so we're going to be busy.
Yeah, Judge, my client was really adamant about going to trial. This is like a 3-year-old accident. And so, you know, I understand the courts. I've told her, you know, what's going on.
How much time do you think it would take to try it?
2 days at most.
At most. And that includes jury selection, I think.
Judge, I'll just probably stipulate to the first 12 and let's go. We're ready to go.
You know, we could get creative. The thing that kind of messes us up a little bit is holidays for the end of the year. But, you know, we could try and Myrna, if you'll look at the calendar, I mean, we could try picking a jury on a Wednesday. And like, I'm thinking like Wednesday, the 15th
Of
November.
Okay.
If you think we can, I mean, I feel like I'm going to be a little bit light at the end of that week without looking at the calendar because it's the week before the Thanksgiving week. So
Right.
if we could, you know, get a jury going, go on Wednesday, Thursday, maybe be done by Friday.
Easily.
Yeah, that would be easy if I can get there. If not, I can get some help maybe because I do have a trial in Laredo and one in Hidalgo County on the 13th. But of course, I don't know if those are going or not, you know. And if the court set this down, I could ask for continuance, and if they don't grant it, then somebody else will have to try them.
Myrna, how does that look on the calendar?
On the 17th, which is that Friday, Judge, there's only 5 settings in there, and they're not special settings.
Yeah, I
And-
think we're a little light that week. What do we have the week before though, like on the 10th and the 3rd? Tenth looks okay.
We have just very few settings just because of the holiday for the veterans.
Yeah. The holiday is what, the 13th? Or is it the 10th?
I have depositions and mediations, but those I'm not worried about. I can get those resolved. Somebody
Yeah,
else.
What's the holiday is what I'm trying to figure out. Is it the 10th? Zira?
Judge, it would be that Monday.
The 13th is a holiday?
Mhm.
Okay, let's do that. You want to do the 15th? We'll squeeze in a little 2-day, 3-day jury trial before
Sounds
we
good,
leave
Judge.
for Thanksgiving. Okay,
If the 13th is a holiday, then Hidalgo County is more than likely closed, so that's out. I'll just need to check Webb County, and if not, I can get some help.
I don't know what, I feel like it's the 10th is the holiday, but I don't know. But in any event, it's not the 15th.
Yeah,
And so let's go with the 15th. You all can do with 60 in the courtroom. We will start evidence as soon as we get our jury.
Perfect.
what time,
Okay.
Judge, in the morning? 8:30, 8 o'clock?
We can start at 9. Is that okay?
I'm sure we can pick a jury by noon. for sure.
Oh, definitely, definitely. So it'll be in the courtroom. So let's request a panel for the 15th of November. Will Jury Hall let us request a panel that soon? We're only a month out.
I'll check with jury hall, judge, confirm that.
If we can't get that date, just know I'm probably looking at 2024, okay?
Yes,
But
Judge.
for right now, we'll go and set it. Thank you very much.
Thank you, Judge.
Thanks, guys. Bye-bye.